Hello and welcome to this talk about remedies for unfair dismissal. My name's Declan O'Dempsey, and with my colleagues Olivia Faith Dobby and Adam Orringer from Cloisters Chambers, we're providing these presentations to enable people to calculate what remedy they want to achieve from the tribunal, including compensation, before they go to early conciliation with ACAS. So in other words, right at the start of your case. This talk deals with reinstatement and re-engagement, and that basically means whether you want your job back, the one you had previously, or whether you want a job with your employer. The pros for this, obviously you get a job. You could also get an order for back pay, and it's subject to fewer reductions than compensation awards from the tribunals. As against that, you've got to ask yourself whether you want to work for your old employer. The other drawback is that the order itself cannot be enforced by a tribunal, although you can get an extra award of compensation. So it's not like a court order. The tribunal can't order your employer to take you back in and enforce it with the full rigour of the law. So when should you think about whether you want a reinstatement or re-engagement order? Well, we suggest that you should think about it before you make contact with ACAS for the early conciliation phase, and decide it before you decide how much you've lost as a result of your dismissal. We're going to provide some talks later on about how you can calculate what you can claim from the tribunal. So in other words, think about reinstatement and re-engagement and whether you want them as early as possible. And I'll also suggest that you notify your former employer that you are seeking them if you want them as early as possible. So you'll hear these sorts of things said about reinstatement and re-engagement orders by the employment tribunal. You'll hear people say you won't get one, they're very rare, and it's not worth thinking about. Now, traditionally, the orders for reinstatement and re-engagement have been quite rare. They've not been the favourite tool of tribunals, partly because the process gets slightly complicated towards the end. However, they are the primary remedy for unfair dismissal which the tribunal has, and the tribunal has to ask you whether you want your or a job back with the respondent. So it's important to take the sayings about reinstatement and re-engagement orders with a pinch of salt, because the fact is that a lot of people don't apply for them in the first place. In times of recession, having a job is probably more important than having compensation. So it's worth having a think about seeking reinstatement and re-engagement, provided you can stomach it. So what are these orders? An order for reinstatement means that the claimant gets the exact same job back. A re-engagement order is slightly more flexible. A similar job is given to the claimant. And if the tribunal makes a declaration that the dismissal was unfair, it has to consider the remedy to give, and it's got to explain to the claimant what orders for reinstatement or re-engagement can be made against the respondent and when they can be made. And it has to ask you if you want them to make an order. So what's the best approach to claiming it? I'd suggest you mention it in any letters you send before presenting your claim to the tribunal. Mention it to ACAS if you're talking to them in early conciliation. Certainly mention it to the employer. Claim it in your claim form. And in your letters you could say something along the following lines, although choose your own wording. I understand that I'm entitled to claim my old job back as one of the orders I can get from the tribunal, and I'm going to ask the tribunal to make a reinstatement order, or failing that, a re-engagement order. What happens if you claim reinstatement or re-engagement after you've presented your claim form? Well, nothing is the short answer. There's nothing to stop you claiming it after presenting the claim form. You should claim it at least 7 days before the hearing for the reasons I'm going to go on to. You can just ask for it at the hearing. If you've given 7 days warning that you will seek an order, then the respondent to the tribunal has to be prepared to deal with the legal questions and evidential questions that arise about whether you can have your old job back. And if the respondent doesn't come with the relevant evidence to show why it might not be reasonably practicable, the tribunal may adjourn the case. There's a special rule dealing with costs, which means that you'll get your legal representative's costs in those circumstances, or your preparation time costs. However, if you claim it late, you shouldn't be surprised if the tribunal accepts that it's not practicable to reinstate you. How does the tribunal decide what to order? Well, it's very important to remember that it is a discretion for the tribunal. So in other words, you have to be able to persuade the tribunal as to what you want them to do by pointing to why it would be the most just solution. The tribunal, in other words, has got a general discretion and has to take into account relevant factors and exclude relevant factors from its consideration. It has to look at some particular factors as a result of statutory requirements. But remember, it's up to you to persuade the tribunal to consider the points in your favour about why you should go back to work for your old employer. Reinstatement, then, is an order under section 114, that's where it's defined, and that defines a reinstatement order. It's an order that the employer shall treat the complainant, that's you, in all respects as if he had not been dismissed. So in other words, all of your rights, including those from contract, must be the same. And if you would have benefited from some improvement in terms and conditions, then the respondent's got to treat you as if you had got that improvement from the date you would have got it if you had not been dismissed. In a reinstatement order, the Employment Tribunal must set out what the terms and conditions are, including the improvements, and specify the compliance date. Turning next to re-engagement, defined under section 115, this is more flexible. It doesn't have to be only with your previous employer. A successor or associated employer would do. It doesn't have to be the same job as you had, but the new job has to be comparable to the one from which you were dismissed, or it has to be some other suitable employment. The tribunal is required to specify certain aspects of the job, like the rate of pay, and it also has to specify the date for compliance. If you didn't contribute to your dismissal by any morally blameworthy conduct, the tribunal can make the order, or must make the order rather, on terms which are, so far as is reasonably practicable, as favourable as an order for reinstatement. So in other words, they will try to make the new job's terms and conditions as favourable as the terms and conditions that would have existed for the old job. However, they can put conditions which you have to comply with. So, for example, complying with a grievance procedure or the disciplinary procedure. Contributory fault, as it's called, then, doesn't prevent you from getting a re-engagement order.